Member of the Nebraska Council for Discipline's Advisory Committee, and he drafted Ethics Opinion 1504. He graduated from the University of Nebraska College of Law. Thanks, Mark.
Hello. So as Sarah said, my name is Mark Porto. I'm an attorney in Grand Island, and I'll just start off right off the bat by warning you. I don't actually do much GAL work, so when it gets into the intricate questions about a guardian ad litem's responsibilities, I may not be the best expert in that regard, but I am a member of the, as Sarah said, the Lawyers Advisory Panel, or committee, I should say. And I just wanted to, I guess, start by giving you a little introduction about some background about what the committee does and how it, what the structure of it is. And essentially, this is a committee that consists of statewide attorneys who are appointed by the various members of the Supreme Court in conformity with their various districts. And so what happens is, at least with me, Justice Connolly just called me one day and asked me to do this because he needed to replace the prior member, and here I am, I guess. So when somebody has a question about, they want to have some sort of an interpretation about an issue going on, they write to the committee. Usually goes to Mark Weber or Dennis Carlson previously, and then they refer them on to the committee, and then the question gets sent to us, and it gets assigned to one person in the committee to draft a proposed opinion, and then we distribute it out among the other members in the committee until we reach a consensus about the opinion that then becomes the published opinion. And so there's a lot of back and forth that goes along with it. What we've decided to do recently is sort of try to flesh out people who have genuine, real questions, as opposed to some people who may have something on the tip of their mind and ask us for an opinion, because it really is a very intensive process for us. So what we've asked going forward is for attorneys to actually include with their request a proposed draft of what they believe the ethical rule entails, and then we review that and either adopt that or adjust it, however we believe is based on our interpretation as well. So it's an interesting process, and so I was assigned opinion 1504, which is probably the most intricate, I would say, complicated one we've had since I've been on the committee. And so I'm just going to go forward through what the original question was and sort of how we resolve the issues that were presented to us. And if anybody has any questions at any point, obviously feel free to stop me and ask, and I'll do my best to answer it. So essentially, what the question that was presented to the fact scenario that was presented to us was that here in Douglas County, there was a subset of attorneys who had reached contractual agreements with the county board to do guardian ad litem work on a flat fee basis. And the concern from the individual who sent the request for the opinion was that the county board was represented in these contract negotiations by the county attorney's office, who at the same time is obviously the party who files the juvenile cases that necessitate the GAL representation in the first place. And so there was some concern among the requesting attorney that this presented a conflict of interest based on the attorney's personal financial interests. And so, in addition to that, there was some concern about the fact that these attorneys were paid by the directly through flat fee arrangements with the county, as opposed to the more, I guess, for lack of a better word, traditional arrangement, at least from where I practice, in that usually there is, attorney will document their time, they'll submit their time in a motion with the court, and then the court issues an order that orders the attorney to be paid. And so because these contractual arrangements sort of bypass that more traditional method, there was also a concern that the arrangement violated the ethics rule that governs payments to an attorney for representation by third parties. So I'll sort of take these issues in turn. And again, if you have any questions throughout the discussion, feel free to chime in, and I'll do my best to answer them. So first question, again, was there a conflict of interest, a potential conflict of interest at least, based on the fact that based on the risk of the lawyer's personal interest in obtaining these contracts and maintaining the contracts in the future. And if you turn to Rule Professional Conduct Section 3501.7, that governs what are called concurrent conflicts of interest, which are essentially conflicts of interest with a current client. And subsection A2 says that a concurrent conflict of interest exists if there is, and this is the key phrase, there's a significant risk that the representation will be materially limited by personal interest, by the personal interest of the lawyer, among several other things, but that's the one that was applicable. And so the question that we had to deal with, obviously the phrase significant risk is vague and open to a great deal of interpretation. And so we did not have any specific information about how much these contracts were worth, what percentage of the income of the attorneys who were operating under these contracts, what percentage of their income these contracts represented. And so without that information, it was tough to make any sort of definitive calculation as far as what constitutes a significant risk. But I think, like a lot of the other ethics rules, you sort of know them when you see them, and I guess it's within bounds of reason, I guess, is the phrase that we use pretty commonly. And so you can imagine, and I think we kind of gave some examples. If these contracts represent, 1% or 5% of an attorney's annual income, then perhaps there is not a significant risk that the lawyer's personal interest in these contracts would materially limit their representation. I should say, let me back up just a little bit. The risk, obviously, is that the responsibilities and duties of a guardian ad litem is to advocate, as you all know, primarily for the best interests of the child, whereas the state, represented by the county attorney's office, is advocating for the state, a different party. And I'm sure you all have encountered scenarios where you, as guardian ad litem, have not necessarily had the same thoughts or opinions about the direction of a particular juvenile case and what is in the best interest of the children that you represent. It may not be the same thought or opinion as what the state believes is the best. And so the concern, obviously, is if a contract for an attorney is such a significant part of their income that it becomes a real issue, and they have a real personal incentive to maintain those contracts. There's at least the appearance or the possibility that that such an attorney could be influenced by, consciously or subconsciously, by their desire to maintain those contracts and sort of conform with the interests of the county attorney's office, as opposed to doing what is necessarily in the best interests of the children that they're representing. And so what we indicated was several factors to look at. Again, the percentage of the income that such an attorney, such a contract represents for an attorney, the total amount of the contract, and any other. I mean, these are not exhaustive by any means, but so you kind of use your own imagination as far as what to look for when deciding whether or not there is a significant risk that the lawyer's representation will be materially limited by their own personal interest in the contract. Okay, any questions so far? All right, so the next step of this analysis, though, brings you to the whether or not, if there is, in the event that there is a conflict, whether it is waivable. And I think from doing this, I mean, I remember taking the NPRE and all that, but being involved in this committee has sort of opened my eyes and become really clear that the ethical rules, I think a lot of attorneys sort of, and I don't mean to disagree with this at all, but I think a lot of attorneys have a misconception about what really they can and can't do, and they probably err on the side of caution more than they really have to, because most conflicts, not all, but obviously, but most conflicts can be waived through the adherence to informed consent by the client, written informed consent, I should say. And so this, a conflict under 501.7A2 is one that is potentially waivable. So even if there is a significant risk that the attorney's representation would be materially limited by their own personal interest, there are factors that are set forth in 501.7B 1 through 4 that lay out the fact that this conflict can be waived if there is informed consent by the client, if the representation is not prohibited by law, if the lawyer reasonably believes that he or she will be able to provide competent and diligent representation irrespective of the conflict, if the conflict doesn't involve one client in direct conflict with another client, or asserting a claim against another client, and finally, yeah, if each affected client gives informed consent. So in this case, in theory, if the client is able to provide informed consent to a potential conflict, it is something that at first glance could be waived. But in the research of this issue, the fact that guardian ad litems have a real unique role and have their client is not as clear as most cases, we ended up coming to a different determination in this particular instance. And that's because, obviously, as you all know, section 43272, subsection 2, states that attorneys appointed as guardian ad litem are not only appointed to represent the juvenile to the extent that they can, but also, quote unquote, the interests of the juvenile. And so what we concluded was that guardian ad litems don't, their client is not just the child, it's the interests of the child. And I know from my prior guardian ad litem work, the interests of the child and the wishes and desires of the child are usually in conformance with one another, but not always in conformance with one another. And so they're different clients. And because of that, in order for this conflict to be waived, not only would informed consent have to be obtained from the child, but also the interests of the child in order to constitute a proper waiver under 3-501.7 subsection B4. And obviously, because the child, the interests of the child is a sort of theoretical client, not one that is capable of providing informed consent, we ultimately concluded that if there is a conflict under 3-501.7A2, in that there's a significant risk that the lawyer's personal interests would materially limit the representation, then this is simply not a conflict that can be waived under 501.7 subsection B. So I hope that that sort of thought process makes sense. I think obviously it probably produced some sort of an impact in light of the concerns and the number of attorneys that had these contracts, but I think it was critical in the analysis to really recognize that guardian ad litems don't just represent an individual, they represent the interests of that individual, and those are different. Those are different clients, and so if there's a conflict of interest with respect to the interests of the juvenile, then because it's just not one that is going to be able to be waived. Okay, any questions up to now? All right, so the next question that flowed from the original concern from the attorney who submitted the request for an advisory opinion involved the fact that the fees were paid by the county board pursuant to contract, as opposed to through a court order, if as would typically occur if, for instance, the judge said, I need a guardian ad litem in this case, I'm going to appoint, Mary Smith, and then Mary does the work and then submits an itemized statement, and the judge issues an order for payment. The more typical process, because there was not a court order, there was some concern about whether the representation potentially violated 3-501.8, which governs the payment for services by someone other than the client. And so in the way of background, 3-501.8 F says, and this we'll get into the importance of this, but it's pretty unequivocal, and it says a lawyer shall not accept compensation for representing the client from one other than the client, unless, and then there's three things again: unless the client gives informed consent, There's no interference with the lawyer's independence of professional judgment, so you're not going to be sort of told what to do in representing the client by the person who's paying for the services. And information related to the representation is protected by Rule 1.6, which governs confidentiality duties that are owed to the client. And so when we got into this, what was interesting to me was that the request, I think, sort of presupposed or anticipated that there was a distinction between payments being made by pursuant to a contract versus payments that are made by court order and then paid by the county pursuant to that order. But when you look at the plain language of 501.8, there really is just nothing to latch on there that would separate those two methods of payment, and which would render the payment pursuant to a contract with the county board problematic under 501.8, but not at the same time cause a problem with being paid by the pursuant to a court order for payment. And so under either scenario, the bottom line is that the lawyer would be accepting compensation from someone other than the client. It just is what it is. And so as a result of that, in order to get around that potential conflict, the lawyer would need to get informed consent, again, from the client. And so the implication of that is pretty significant, and that was one thing that I certainly recognize, because I do my fair share of criminal defense appointments, and this would not obviously be restricted just to guardian ad litem work, but the takeaway from this is, if you have a court-appointed case, because you're not being paid by the client, you need to get the client's informed consent in order to comply with Rule 501.8F. And I don't think that that's something that has been an active practice by many lawyers. I think would change I think it probably does change the dynamic a little bit. So I researched that, and I found that this same issue had come up previously in other states, and there was an Idaho case that we cited in the opinion that basically said the same thing, which is this. Our rules are governed are based primarily off of the model rules that are uniform throughout the country, and they said essentially the same thing. This is pretty plain language, and there's not there's no real clear exception for court-appointed work. And so what that opinion said was, even if it's a court-appointed case, you nevertheless need to get informed consent from the client that your services would be paid for by someone other than the client, so the county or the state or whoever it is that is providing payment for the court-appointed services. And so, why that is a significant change, the sort of begs the question: is it really a problem? And I think that's unclear, but I tend to err on the side of having more communication with your client, being more upfront with them about how you are getting compensated for your representation, how you do represent the client, irrespective of who's paying for your representation, and sort of having these sort of frank discussions with the client does nothing to hurt the relationship with the client, and could actually benefit by helping helping resolve some questions about trust and about who do you really represent. I know I get a million questions from clients that right at the outset, who I am appointed to represent. Well, are you just working for the county and those sorts of things. I can't tell you how many cases I get where they say, well, I don't want to have a public defender, and I'm like, well, he's probably a better lawyer than me, but whatever. And so if you have these discussions with the clients at the outset, I think it will. I think it helps the attorney-client relationship, and we just didn't see any way around that based on the plain language of section 501.8. Yeah, go ahead.
So that's, is there a difference between just giving assurances to your client that, your loyalty is to them and not, the county? Or, does it take an additional step, or?
Well, it requires informed consent. Which would require written informed consent. So, I think what attorneys probably need to be doing is drafting up a document that explains to even court-appointed clients, this is who I'm being compensated by. My duties are to you, not to necessarily to who it is that I'm being compensated by, and written documentation that they acknowledge that you've had that conversation with them and that they're waiving that potential conflict. Now, if they don't do that, I don't know what happens then. I don't have a great answer to that, and I'm not naive in that this may be something that that may want to be revisited at some point in the future. But the language of 501.8 is so clear, we came to the conclusion that we couldn't simply just look beyond that. Yeah, you.
Mark,
Sorry, one second.
can you repeat the questions for those who are listening remotely? They can't hear the audience.
Yep, no problem.
Thank you.
I was going to ask, would the client's request for appointed counsel and the financial affidavit that he fills out to the court, wouldn't that constitute informed consent?
So the question was, would the client's request for court-appointed counsel and the filing of a financial affidavit be sufficient to constitute informed consent? Maybe. I think it would depend on what exactly the financial affidavit says. So that very well could be. I don't have a cut and dry answer for that, because I think it varies tremendously from county to county. Some counties that I practice in, I know, are very strict in the financial affidavits. They will deny court-appointed counsel, and the judge will meticulously look over whether or not this person is entitled to court-appointed counsel. Other counties that I practice in they just almost take it for granted and simply go ahead and appoint court-appointed counsel, just as a matter of course, because I think, in particular, when you have like arraignments or things where there's a lot of people waiting, and the judge doesn't want to waste the time to go through a financial affidavit, or may not even require one. Sometimes they just appoint counsel, and so I think it depends on the circumstances and what the financial affidavit says in particular. But conceivably, I can see how that would cover it. So, any other questions right now? All right. So the obvious question then became, well, what do we do about children, about people who have legal proceedings brought for the specific purpose of, caring for them? So you have a juvenile, a 3A case opened to help, a 5-year-old. What do you do if you're guardian ad litem to obtain informed consent? Because one, you have a minor who is incapable of providing truly informed consent. And we have the same issue that we talked about previously, in that you're required to represent not only the child, but the child's interests. So how do you get informed consent from this conflict in such a scenario? And I think what we did at that point was, there was some prior case law and ethics opinions that have recognized the general proposition that, you try to interpret rules so as to avoid, a truly absurd result. And so in this, what we concluded was, if it is a scenario in which the client is incapable, either by their age or by their amorphous status, being the interests of the juvenile, then the representation is impliedly authorized, notwithstanding the fact that compensation would be provided by someone other than the client. And so therefore it would not run afoul of 501.8. So I guess the takeaway from that, if you have a court-appointed case, our interpretation is that if the client is capable of providing informed consent, then in order to be in compliance with 501.8, you need to get informed consent in writing from the client. If the client is incapable of providing informed consent, then the representation is impliedly authorized. And again, to go back to Duke's question about whether the financial affidavit could suffice, I think is probably dependent on on the specific language of the financial affidavit. Potentially, though, I think that it could. Maybe the best practice would be to just develop a standard form that you go over, right off the bat when you're appointed to represent the court-appointed client. Okay, and then the last question that we had on this issue involved, there were some issues, and as far as I could tell, there was some concern about the level of sort of detail that was or was not being provided to the county board by the attorneys that had the guardian ad litem contracts. And so, obviously there were questions of oversight, what amount of work is going into these cases in order to justify the fees that were being paid to these attorneys. And there was I think there was some disagreement in terms of what degree the attorney could indicate they had been doing for the client without running afoul of duties of confidentiality that are laid out in 501.6. And what 501.6, again, you have another one of these vague rules, which are not uncommon in the ethics rules, which is why people come to us for interpretations. But it just says in subsection A, lawyer shall not reveal information relating to the representation unless the client gives informed consent. And so, the question that we're trying to answer here is, what does quote unquote relating to the representation mean? And here, what we ultimately decided was, the fundamental purpose of this rule is to ensure that clients feel like they can talk to their attorney bluntly and unequivocally without fear that the attorney will disclose or discuss what the client says to them in confidence. And again, it's one of these things where if the client says, my name is John Smith and I was born on April 5th, that's probably not something that that's going to to chill or cause a problem with the client's level of trust with the attorney. But if the client says, yeah, I've been using drugs, but I nevertheless, want to get my kids back today. Yeah, I mean that would cause some problems if that information is disclosed. And so what we concluded was, in any purpose, whether it's to discuss the case with other attorneys, or whether it's to provide justification for billing to a county board, to a judge, or to the client, him or herself, or to some other third party who's paying the client's bill. We concluded that related to the representation is information, if disclosed, would either chill the client's propensity to disclose truthful information in the future, or would otherwise negatively impact the client in any way. And maybe that's not the most helpful language, because it continues, it's still pretty broad, but I think it provides some degree of framework. If it's as simple as, I went to Johnny's school on today's date to talk with his teachers about what was going on. Probably pretty innocuous. Probably not going to be something that, if it's disclosed, would chill the representation. On the other hand, if it's I went and spoke with Johnny's counselor about the results of his sex offender evaluation, and here's what the doctor disclosed to me that he continues to have problems. I mean, yeah, obviously that's going to be an issue. And so I think it's one where attorneys just need to use discretion and common sense and to make decisions about bottom line question. If I disclose this, is it gonna chill the client's desire to want to speak with me and be open and frank with me in the future? Would it hurt them in any way? And if it does, then it needs to not be disclosed. And there's really no exception for that. So, I guess there are some, like if you're ordered to do something by a court, then you can. But short of that, that was the best we could do for that portion of the request. So that was the sort of the resolution of opinion 1504. There was a lot going on. I don't think that the requesting attorney probably anticipated that we would find that there really was no distinction between whether the compensation for payments were made by the county board versus the court, but there just again was not really a basis to conclude otherwise from the ethical rules. And so we came up with, I think, probably the most significant aspect of the opinion is that if it's a court-appointed case, you still need to nevertheless, in our opinion, get informed consent in order to be in compliance with 501.8. That's about all I've got. If anybody has any questions, I'd be happy to answer them. Okay, thanks.
Thank all of you for coming. My name is Larry Gembler. I'm a juvenile judge in Sarpy. I've worked in the building since 1977, and I've been in juvenile court as a judge since 1992. I just want to thank all of you for the work that you do. It's not easy. Sometimes it's not recognized often enough, and I appreciate the fact you're here today and appreciate all that you do.
Hi, I'm Neely Boyer. Is it being picked up?
Is it being picked up?
Yeah. Yes, okay, great. I'm Neely Boyer. I'm an attorney with the Department of Health and Human Services. I do a little bit of courtroom work in primarily the northern service area, and then I also provide administrative guidance in-house for the Department of Health and Human Services. Before that, I was a prosecutor for almost 10 years, so I have a lot of experience on both sides of the court.
My name is Amy Huff, and I am actually a supervisor of family permanency specialists or caseworkers here in the Douglas and Sarpy County area, and I have been doing that since 2009. I don't do a lot of legal representation, obviously, but I work in the court system pretty much daily with children and their families.
I am Gail Steen. I'm a private attorney in Lincoln, Nebraska. I have been in private practice since 2008. Prior to that, I was counsel for HHS. Prior to that, was legal aid, so I've sat in most of the chairs around the bend.
And I'm Christine Henningsen. I'm going to moderate the panel today. I'm the chair of the juvenile law section of the Bar Association. Currently, I'm an attorney at UNL Center on Children, Families, and the Law. And prior to that, worked in juvenile defense in Douglas County Public Defender's Office. So again, thank you everyone for coming out. What we're going to do is, Judge Gendler, in addition to everything he shared with you, he also is the lead judge on the Through the Eyes of the Child initiative, and also sits on the Supreme Court Commission on Children in the Courts, which put together the guardian ad litem guidelines and now rules. And so what we're going to start, he's going to go through the process of development of those rules, and then Gail is going to kind of give us a roadmap how we got to in Ray Sloane, and then we'll do some warm-up questions and open up to the audience for questions as well. So Judge Gendler, if you kind of want to take over.
Sure. Just briefly, the Supreme Court established a commission on children in the courts about 10 years ago. The purpose of it was really to improve the lot of kids and families in the court system, and it also coincided with our work on the Through the Eyes of the Child initiative throughout the state. And as part of that process, there was a subcommittee established on guardians ad litem. And that subcommittee met for over a year and really worked hard in trying to establish some new rules that would benefit these youth and also the guardians ad litem. Those rules were submitted to the Supreme Court, and the Supreme Court took time, a lot of time, to decide what they were going to do about it, and they decided to make them guidelines, even though our commission suggested they become rules. And in fact, that was our recommendation. And then a couple of years ago, we made the recommendation again, we'd like you to reconsider this and make them rules. And one thing about the Supreme Court rules that is kind of interesting, I think, is by rule, Supreme Court rules take precedence over legislation. So they matter. And we wanted this to matter. And as part of the reform effort in the legislature, Senator Christ and others decided that these guidelines needed to become rules. So initially, legislation was introduced by Senator Christ that essentially verbatim repeated these guidelines to make them legislation. And of course, part of the issue with the legislature and the judicial branch is typically the regulation of lawyers and lawyering is through the judicial branch. It's not prescribed by the legislature. So in an attempt to compromise and get some sort of resolution, the legislature passed a bill requiring the Supreme Court to establish rules on guardians ad litem. So as a result of that legislation, these guidelines were then enacted as rules. And that's what you see in front of you. I'm not going to go through them in detail because you can read them yourself, but clearly the rules establish certain requirements and responsibilities that were not spelled out previously by legislation. The other thing, which I'll talk about a little bit later, is I think these rules also provide some options for guardians ad litem that maybe didn't exist before, because clearly you're an advocate for that youth, and you're entitled to be included in all the proceedings, all the documents that are shared, discovery. But I think beyond that, you're given some opportunities to really speak up for that youngster in a way that perhaps wasn't spelled out before. But anyway, that's the process of how we got to where we're at. I know there's some other people in this room that were part of those discussions. I know Kim, you were. So with that,
Thank you. Does anyone have any questions for Judge Gendler at this point?
yes.
In our court, the judges differ in the court orders that they issue when you are appointed. Some detail the rules and others do not. We run into the biggest conflict when we try to get records from counsel, psychologists, psychiatrists, those folks.
I can just repeat the question. There's varying practices between judges when you get the court order appointing you. Some of the judges put in the order the rules, and then some of them don't reference them at all, which makes it more difficult to get copies of certain reports and evaluations.
Each, as all of you know, because a lot of you practice in other courts or variety of courts, we all have we do things differently, and we tend to frustrate lawyers sometimes. I'll just say that. I don't put the entire piece that's in the rule in the court order, but if it becomes necessary, I would. I've never had a guardian ad litem approach me and say they weren't able to access something. But if that actually happened, I would draft another order spelling out what's contained in the rule to make sure that you get what you need.
Okay, thank you.
I just want to, that's another good point, though, is you should always let the court know if you're trying to get something and somebody's not sharing it with you. That's an important thing to know.
Great. And so now we'll go to Gail, and she'll kind of give you a summary of some cases leading up to In Re Sloane, and then we'll open it up for some questions.
There should be a handout that that's in the materials that were put on the web earlier. That's just kind of a little short list of some of what I thought were kind of the relevant cases that got us to Sloane. It starts with Kelly D. That's the case where the mom thought she was having sexual fantasies or sexual thoughts towards one of her children. She was not the custodial parent. And that started the line just kind of questioning, what do you do when you have one fit parent and the other parent is not, or there are allegations against the other parent. And Kelly D started that line of starting talking about that. It talked about, this is where we get the lovely language, we do not have to wait for harm to befall the child before we take action. So that's kind of the start of the cases for me. The next significant case was Stephanie H. In that one, it became then the understanding that you had to wait until disposition before you could really assert your right as a non-offending parent. We still talked about adjudicated, not adjudicated parents at that point. But then it went on to that if you are a fit parent, it's still the state's responsibility to show that you are an unfit parent. So again, made it clear the burden is on the state as opposed to on the parent to show fitness. The next big one was In Re Devin W, and I think this one was also kind of a little ground shocker for a while. It took out the offending parent language, it took out the adjudicated parent language and said everybody's adjudicated once we have jurisdiction over the child. So we're not talking about adjudicated, not adjudicated. So then we started talking about non-offending versus offending parent. That's the case that began to clarify that you could still have jurisdiction even if you had a parent that was fit. It still didn't really answer the question of why are we still in juvenile court if we've got a fit parent. In Re Sloane came out just recently. Karen Nelson is here, so we're going to pump her later for questions about that case. But In Re Sloane was a case where allegations were filed that inappropriate disciplining by dad. Mom came to court and said, I'm mom, here's the birth certificate, I'm mom. Judge did not allow her to intervene. Then there was further hearings, and she said, and I want custody. And by the way, I have a temporary custody order from district court. The child was also a law violator. Was she a law violator or 3B? She was a law violator, so there was probation involved as well. So Sloane clarified that probation doesn't have custody. Probation can supervise a case, but it's not a custodial person. It also clarified that a mother can show up, show that she's mom, and that's enough. She's automatically a party. It also clarified, it also raised the issue that if there is a fit parent and there is no filing against that fit parent, that parent should have custody. The case didn't actually give mom custody. When it was decided, it remanded the case back. Karen updates that the case is still a mess. The child is still in care. Child is at Boys Town and one of the levels at this time. There's a second appeal that's going to be coming up, so there is not a clear answer on that case as to what happens when you go on remand, what happens when you have a fit parent. We're going to discuss a little bit later about what we're just seeing once the case is remanded. The other couple cases I'd point out to you, since Sloane was published, there's also In re Maya T and to Candace H. It's a Court of Appeals decision for 2016. It's out of Lancaster. When you read this case, it's like Sloane doesn't exist. It doesn't, to me, it doesn't jive with Sloane. In that case, the father was not filed on, but dad showed up. There was a filing against mom. The court ruled that if dad wanted custody, dad had to do A, B, C, and D, even though there was no filing against dad saying he had done anything wrong. So that got appealed up to say, why does he have to jump through hoops if no one's going to prove up anything? The Court of Appeals said, essentially there's a fundamental and material difference in the case from the prior orders, so it allowed the appeal to go forward. Said there was a statute change to take out custodial parents. There was evidence of unfitness, so we're just going to slop it over and say that's good enough. There's still no filing against dad, but they said there was evidence of unfitness. The attorney that represents dad is taking that up for further review. Her brief was just in last week. She did cite Sloane, so we'll see what the Supremes do with that once they take a look at it. There's also My King K, which is also a recent case. It's in the advance sheets now in March of 2016. That is out of Douglas County. In that case, mom was filed on, was terminated or relinquished, so she's out of the picture. Dad is identified late in the case. He's identified by a filing. They file a sub 2 and a sub 7. Sub 2 is substantial and continuous neglect. Sub 7 is the child's been in foster care for 15 of the last 22. That case, while the termination is pending, the judge also orders dad to do certain services and also starts visitation with the child even though a termination is pending. When they get to termination stage, the judge finds there's a termination basis, that gets appealed up. The Court of Appeals clarified that dad can only be responsible for the time that he knew that he was dad or had a reasonable suspicion that he was dad and when he knew the child was in foster care. So that still opens the door to all these dads that have no idea they're dads until CPS comes a knocking. It also commented about minimal efforts from HHS to try and find dad. The worker testified that at least 3 times a month she did some sort of effort, either calling him, checking in focus, checking jails, checking Facebook. So she was making some effort. She did have some communication with him. Dad was not overly responsive to her, but she was making at least some attempt to try and contact him. The Court of Appeals said they were not together at birth. The department hasn't made much efforts. So until we actually had a conversation with HHS, that's when the clock started for that dad. And even though he wasn't determined to be dad, the department notifying him, the fact that he knew he had a relationship with her, that was enough. In this case, at the Court of Appeals level, they did terminate his rights by saying that he neglected and refused because he was pretty much dragging his feet into the juvenile court. They'd asked him to do genetic testing. He said, I don't want to because I'll have to pay child support. They said you can do this, this, and this. And he's like, well, if I have to. So he was just kind of slow to get moving. And so they said that shows that he is not really interested in having custody of the child. That, again, is a Court of Appeals. That's actually a non-published opinion. So it's just kind of watching the sheets and seeing what happens.
Great. And so I wanted to open it up to any of the other panelists who wanted to add to the summary. I heard some grunts.
No, I just want to make one clarification. On Maya, there was a supplemental petition filed against the dad. And essentially the allegations are that he failed to participate in these programs, so he didn't put himself in a position to be able to have his child placed with him. So that's an interesting concept, that there were no allegations against him previously, but now because he hasn't done anything, now we're going to file on him. And I'll talk about that a little bit later, at least how we might handle that in Sarpy. But that's the interesting twist on that case, is there's something pending, but it's a result of something where he was never initially filed on. So now they're using those behaviors post-filing when he had no requirements on him against him. So we'll see what happens.
Neely or Amy have anything to add to that? So the first question is, and this is to all the panelists, since the decision in right interest of Sloane, have you seen any changes in court practices or in your agency practices or procedures related to the decision? Like, are cases filed on differently? What's the proper term to use with the parents? What services are due to each parent, either filed on or not filed on?
Well, I don't mean to be dominating this. And Peg Stevens worked with us when I was in the county attorney's office. This case really hasn't affected Sarpy County at all. Because in our petitions, we always file on the non-offending parent. It may be through no fault of the parent. There's been little contact because either it's a big distance where they live, or the mother has kept the child, or the father hasn't had an opportunity because of his personal circumstances. So every parent is identified on the petition, and in fact now at our pre-hearing conferences, if there's a question as to who may be the parent, we also will include the other guy and come in and get him tested, if he wishes, to determine if he's actually by DNA testing, the genetic testing, the father, because we need to find that out early on. And I had one lesson in this that was really good for me, and we had a father who was not on the birth certificate, who we located early on, who said he might be the father. And he had had no contact with this girl who was 7. So immediately everybody was thinking, this is going nowhere. Why do we even want him in her life? He really didn't know her. A year later, we closed the case and she went with him. He was a fabulous person. He just didn't know where his daughter was. He didn't make the right effort probably initially, but it was a good lesson for all of us, because sometimes these folks at first blush we don't think are worth the effort, and we find out later they really are. But in terms of our process in Sarpy, Sloane's really had no effect.
I have a different perspective on that. I practice in a lot of the more rural counties, and what I've seen in some of the counties where I have attended court is that Sloane has been a really good reminder to everybody that the non-custodial parent has rights that shouldn't be overlooked. And I've seen judges more willing to return custody or give placement to non-custodial parents in situations where maybe before Sloane, even though I think Sloane, with regard to parental preference, it's basically just reiterating what was already out there, but it just reminded everybody what should be at the forefront of consideration. From a DHHS perspective, our policy has been for years now that the non-custodial parent should be the person that we are looking to for placement right away. If we can't maintain the child with their custodial parent, we should be looking at the non-custodial parent. That should be our first preference. I think, and I think again, Sloane is a good reminder to everybody to follow the policies that are in place and the law that exists. I think one of the big differences for HHS workers is we might have been good at looking at the parents for placement, but I don't think we ever were really thinking about, should we be asking the court to give custody to these non-custodial parents? And so those are some of the policy decisions that are going to have to be made now at this point in time. Is it the department's job to go in and ask for custody to go back to the non-custodial parent? Is it that a parent's attorney's job? Is it the guardian ad litem's job? Is it everybody's job? So I think that's one of the things one of the changes that will probably be coming about from a DHHS perspective.
I guess I would echo some of the same she says, because we work closely with the department. NFC, I would say that we had always had it be our policy that we're diligently searching and looking for non-custodial parents and placing with them with all possible. I would say that the only difference I've seen is just making it come to the forefront again and reminding us of how important that is and that there could be suitable parents out there. This was before this, but I know I had a situation in which we located a father in California, much like Judge Kindler said, who was very appropriate, but this child was 12 at the time that we found him, and he had had contact with her when she was younger, but not for like 6-7 years. And it was mostly due to the mother moving and not maintaining contact with the father and him not sure where they were at and him probably not making the appropriate efforts. However, he was completely appropriate, we placed the child with him in California and closed the case out successfully. And I have quite a few stories like that, and I do think that if our diligence would have been more, I guess, diligent at the beginning, that those things could move along faster. And so I guess the biggest change I've seen is just bringing it closer to the attention and knowing how important that is, that there are a lot of custodial parents out there that are appropriate and could get placement, and that would be in the child's best interest. And ideally, my personal opinion is helping the offending parent get in a position to where they can co-parent. I know that's not always possible, but that's what I like to see. And if we can do that through the juvenile court so that they can co-parent or have visits, that's really what's best for the children.
In Lancaster County, I do see a difference. For language, we're talking about that you get Sloaned, that if, suddenly you can come ask for custody, that may impact your case. And that non-custodial dad may be a Sloan dad. That's kind of some of the terms we're using. There is I had a case in 2009 where the dad was determined to be dad by paternity. Mom then has a subsequent filing. Child is placed in foster care with a relative. At that time, my guy could not get custody because he did not have an existing relationship with the child. And even though he was, there fighting for that child and said, I will take her in a heartbeat, I will do what you want me to do, the child was never placed with my client. He started off with supervised visits, etc. I think now with this case, I would have a much better chance of having that child placed with my client. I had a case then in the last year, kind of similar case, newborn child, dad was there from birth saying, I am dad. HHS said, we're going to do genetic testing before we set up any visits. We're not really going to look at you until we have the genetics back. That was sometime in July that we got genetics back. The child was born in April. Then in August is when HHS actually looked at the genetics and said, oh gosh, your dad, maybe we should set up visits. Well, we'll do that in a month or two. So he didn't have any visits until October when the child had born in April. He also didn't have court-appointed counsel until October. So we immediately filed ask for custody because of a variety of reasons. Their hearing could not be held until December. In December, the judge said, yep, child goes with dad. She said, I want a brief transition period just to try and make it easier on this young child because she only knew the foster parents really as her parents. But the judge said, I'm concerned about how this case was handled. Law is clear. Dad is not, there are no allegations against dad. He should have custody. So I think it's a huge case for non-offending dads, well, non-offending parents, period.
So, Duke has a question.
Yeah, a little bit. Everybody keeps using the term placement.
Here, I'll bring the mic up to you. That'll be my job as moderator. No, there's people on the web, so I feel like it's a talk show.
All right, so far, panelists have used the term placement and custody kind of interchangeably. I see a distinction between the two, particularly when you're talking about unmarried parents, divorced parents, or parents that are still married and haven't gone through a divorce, whether they have legal custody, physical custody. Could you explain the nuances of the difference between whether the child is placed with a parent and whether they actually have custody?
I guess I have my mic. It's a good question. Duke and I are high school classmates. Our 45-year reunion's coming up here soon. I think we have to be careful as a system because we have several options, as you suggested. One of our options is we can vacate custody and just place the child with a parent, or we can maintain custody and place the child through the department with a parent. And we always have to be mindful that we've done those steps. We need to remind people when they come into the system that all of our orders in juvenile court are temporary. we don't have the authority to decide permanent placement. That's going to be in a custody dispute. Maybe that gets transferred to us. But everything that we do is temporary. So even if we place with a non-offending parent, that's a temporary placement. It's typically not vacating custody with the department. And we need to explain to the dad who might get that child temporarily, understand that the mother still has rights, understand custody's with the Department of Health and Human Services, not with you. And regardless of what we're doing here, this is all temporary because there may be another court that comes in and decides differently, or there may be a different resolution reached later on in the case. So I think you're absolutely right, and I think it's probably my responsibility initially to make sure that parents understand those distinctions, and so they don't get misled, thinking that if we place the child with them, that means the case is over. And it's a great point. I don't know if I answered your question.
Can I just follow up on that?
Sure.
I was just going to say, I think obviously I gave it away earlier when I said the department has always looked for placement, but there's the question of custody. I know that there have been, I've heard some judges who have interpreted Sloane to say when they're talking about custody in this case, they actually mean physical custody as opposed to legal custody. I can tell you from my perspective, the court also as part of the holding says that mom would get custody, but it would be subject to placement by probation. And so I think that the court itself in Sloane, I don't know that, is it still working? I think the court itself in Sloane distinguishes between placement and custody. And I feel as though when I read Sloane, when they use the term custody, they're referring to legal custody, not physical custody. And when the Sloane court uses the term placement, they mean placement, not legal custody. That's how I interpret the case.
I agree with
I agree with Neely's interpretation of Sloane O, and I think that courts need to be careful with parents, non-offending parents, because if you're placing custody in the department but giving them physical placement or physical custody, that parent then has to go to the department and ask for permission to take them to the doctor. And they can't sign enrollment papers for school. The department has to do that. And all the fundamental major decision-making for legal custody, the parent has to go to the department for that. And my final, I guess, question for the Nebraska Supreme Court is, does the department really make a better parent than parents? And I think in a lot of instances, the department doesn't, respectfully. And so I think that the Supreme Court meant legal custody should have gone to the mother in this instance. So I don't think that was an accident. I think Neely interpreted it correctly.
The thing I'll just add on Karen's, they had temporary custody. Mom had custody. She had an order from district court when she asked for custody and placement in juvenile court, and neither of those were honored, and the judge at the time said probation had custody. So it clarified again, probation can't have custody. There's no such thing. It's like HHS can have custody, probation cannot. They're different animals. But in Sloane, she definitely had custody, and she had an order. She was good to go.
This is probably better for Judge Gedler. The one big question I've still had about Sloane O is, in this circumstance, let's say mom gets custody, the child's taken out of HHS custody and placed in mom's custody because we've got a district court order that says she's the custodial parent, she's fit, there's no reason not to. Then we've got an offending parent. So in terms of provision of services and that kind of thing, does the case get closed because the state's intervened? Do we now have an obligation to rehabilitate to a certain level? That's an open question for me.
Well, it's a good question, and there's a lot of variables. part of the issue might be is if parties can convince the court or some of the parties that that parent can protect the child, then maybe we don't need to stay involved. So I'd say oftentimes maybe we don't. And if we do, we need to make it pretty clear the reason for that. And I think Karen's point is a good one. And we can also put in court orders that parents are authorized to do certain things and to make sure that it's clear. But sometimes you'll have the parties request that the court stay involved because they want to rehabilitate the relationship between the offending parent and the child. So we can stay involved for that purpose. You can make things voluntary for the non-offending parent. So the mother in your example who has custody, we can offer some programming to her, but we can't hold it against her if she doesn't do it. That's the issue that kind of concerns me in this Micah case, because it wasn't really posed as voluntary. So I think there's a lot of different variables. I just think you have to be mindful of everybody's rights and hear everybody out. But oftentimes I think if the child is safe in the home of a non-offending parent and we have a resolution that works, then why stay involved? What are we doing? So.
One of my concerns as guardian ad litem after Sloane is we get children placed, let's say, with the non-offending parent, we'll call him the Sloane dad, and we don't know very much about him. And to balance his rights of closing the case because he hasn't shown us he's a problem versus making sure that that really is a good placement, when there's a custody order from before, from a district court giving the offending parent custody, how are we to know that the minute we close that case, those kids maybe don't go back to the offending parent, or that dad doesn't follow up on trying to get custody because that's in a whole nother courtroom? I mean, I think that's the big question that I have right now is, as guardian ad litem, like, how do we make sure that we're balancing dad's rights with probably best interest of the kids long term?
Well, it's a good question as well, but we can vacate custody with the department and just place with the father and give the father time to file whatever necessary pleadings he needs to file in order to obtain custody. And we can give, so I will do an order that places the child with the father, and understand it's always temporary because we're juvenile court. I don't have the custody case in front of me, but that gives the father time to file whatever pleadings he needs to file. And as all of you know, in a lot of circumstances, we'll offer some mediation services and some other things that are kind of outside the scope of the case. At least a lot of jurisdictions do, including us, so that the parents can get that resolved. But that's one way to do it.
And I think tagging onto that, that again goes back to placement versus custody. If you're our non-offending dad and there's nothing filed against you, I think you should automatically get placement. I think then the department's responsibility is to make sure that dad gets custody and checks out that dad. I think that's part of making sure the child is not in a situation dangerous, and that's the reasonable efforts. So HHS has assisted in those situations of getting dad custody or either paying for it or any other thing. So there is that element. So I think the court can retain jurisdiction in such time as custody is resolved. We talked about that jurisdiction now is such that you could file a custody action and ask that it be heard by the juvenile court judge, regardless of what county you're in. So if it's a county court judge, you can ask it be heard by the county court judge with the custody hat. And likewise, if it's in a separate juvenile court, you should be able to say, I want it to be heard by the juvenile court judge. In Lancaster County, the problem is they haven't figured out how to make justice do that. So they are requiring us to do a motion to transfer. My argument with the clerk's office, that's your problem. You can do a hand transfer, just do a manual transfer to the judge. But I don't think a juvenile judge gets to decide whether or not they get that case or not. And right now they're deferring to the juvenile judges of whether or not they'll accept that case. That's what's happening in Lancaster. Most of the juvie judges will take that case. They will take it for temporary custody. The preference is we do temporary custody because that's affidavit only and we don't have to do a full-out trial. If I give you temporary custody, then I want to transfer it, then I want to close the juvenile case, transfer it back to district court, and you people fight it out down there. So that's I guess, the footsteps where I see them heading in the future.
Does DHHS stay involved that whole time?
I think once the juvenile court case closes, no. I think they would have legal custody while dad has placement until dad has custody. Or you can vice versa and say, dad has temporary custody, dad, get your filing on file. Once you have filed it and I've given you a second temporary order, then I'll transfer it down. But I don't think the juvenile court can say, there's a 3A filing, I give dad temporary custody, that created a custody case for just district court, here you go. I think there has to be that additional filing asking for placement and asking for parenting time for either side.
I guess just to respond a little bit from the department perspective. I mean, first of all, I agree that I don't think that the orders entered by the juvenile court are going to trump a district court order once the juvenile case closes. I do think there has to be that separate district court action or custody action, whether you get it assigned to the juvenile court or district court. But there were a couple things that I do think from a DHHS perspective we disagree with. While I think that Sloane gives a presumption that the parent is the right placement and right person for custody right away, I don't necessarily think it's automatic. If the child has already been placed in the custody of the department on a 48-hour hold by law enforcement, the department does have some duty to look at the parent and assess safety for the child before we just place the child with the non-custodial parent. So there's going to be some background checks done. There's going to be a walkthrough of the home done to make sure that we're placing the child in a safe setting. So using the word automatic, I hesitate to use that word because I don't think it's necessarily automatic, but I do think it's a priority preference that should be ruled out before you look at anything else. I would also say that there was some indication that maybe it's the department's job to get custody placed with that non-custodial parent, at least as it relates to the juvenile case. I'm not sure that's accurate. First of all, the way I read Sloane and understand the parental preference doctrine is the burden is on the state to show that the parent is unfit. The burden's not on DHHS or the parent to come and show that they are fit. The burden is on the state to say, this parent is unfit. And unless the state does that, the parent should be getting placement, custody, all of those things. Now, I think the department could certainly show up at the temp custody hearing or whatever hearing you're at and provide information as far as we believe the parent is fit or unfit for whatever reasons, or we have no safety concerns, or we do have these safety concerns. I think the department could provide that information, but I don't necessarily think the burden is on the department to get custody placed with that non-custodial parent. And to the extent that everybody walks in, aside from the state saying, or maybe the custodial parent saying non-custodial parent should get custody, if the judge rules against that, I don't know that it's DHHS's job to continue that fight.
I have a question from one
Oh,
of
sorry. So I think that the non-custodial parent should have an attorney appointed. That person should be certainly advocating for their client's rights. And I also think that as a GAL training, I don't know what, maybe the GAL should be helping to fight that battle as well. I'm not saying DHHS wouldn't, participate. I'm just not sure that saying that the burden is on us to do it would be accurate.
And my point was just about reasonable efforts. The department must make reasonable efforts to reunify. And so is that part of the HHS's responsibility is to assist getting the child out of juvenile court by helping with the custody. So I agree that it's not, HHS has to foot the bill for everything. But I also think when it's a reasonable efforts finding, there is no filing against that parent, then HHS has a duty to try and move forward. As far as whether or not it's the attorney's job, it's been clarified our responsibility is only to the juvenile court, so I don't think I can start a district court action within my scope as juvenile court representation. I can certainly tell my client that, and I can be hired to do that separately, but I don't think it's within my scope. You're not entitled to a court-appointed counsel to do a custody action, so I don't think I can do that just on my own as a parent's attorney.
Well,
You got somebody over here.
We have a question from the
I have two,
web.
actually.
Oh.
We've been waiting to. The first question, you may have covered this, is do you not think the non-offending parent is entitled to temporary custody rights right away or only placement? And then the second question is, what about a child who has had no relationship or possibly never even met the non-offending parent, automatic placement and or custody in the best interest of that child?
I don't know.
That's why it's important the county attorney file on every parent initially, even if it's a no fault. Explain why there's been no contact, at least to make those allegations so that there can be some evidence presented to the judge as to why parental preference should be suspended or what the issue is. So if there's no relationship and the child's a special needs child and has an IEP, we certainly shouldn't be putting that child in the non-offending parent's home if they have no relationship with them. But that's going to require somebody to actually make those allegations and present some evidence.
So those of us who don't live in Sarpy and the county attorney doesn't file, how does the department or NFC, if the judge poses that question to you, how do you respond then?
I know if we get asked about that, we let the judges know that we're assessing for suitability. Usually they'll ask us for a time frame, and that has to be very quickly, like she's saying the 48 hours, but that can be done very quickly. The walkthrough, the background checks, meeting with the parent, asking for their ability to provide care for that child and their understanding of what the needs are. Them knowing their child and understanding needs are two different things. That can be built through placement, through transition. So I really feel like that is our job to assess that and determine that and then provide evidence of that. And then at that point it would be, I guess, determined upon the judge whether they thought the placement should happen right away or transition.
And to follow up on that, I also think you have to look at the different circumstances of each case because, quite frankly, maybe you're talking about a non-offending parent who doesn't have any relationship with a child, but they're still a parent, and maybe they live in that same town, the child could stay in the same school district. I mean, basically all the concerns you would have for the best interest of the child, and they could be placed with the father who we have no reason to believe is unfit. If we place them in foster care, they're more than likely going with somebody they've never met before either. So I do think that you have to balance that. I think you have to look at the totality of the circumstances. Yeah, maybe if the non-offending parent lives at the other end of the state or something and you're going to be disrupting this child's whole life, maybe that's something different. I also think under the parental preference doctrine, you could try and argue maybe that by lack of contact they've forfeited their parenting right, which would be another way for the courts to say we don't have to place with that parent. So you can argue it both ways, but I think that's something that needs to be taken into consideration. And then also on the first question, as far as whether the non-custodial parent is entitled to temp custody right away, I think the issue is a lot of these cases start with law enforcement removal and a temp custody order placing the child in the custody of the department. So that court order has to change in the juvenile court case before that non-offending parent can have custody. So that's where I think that at the temp custody hearing or whatever hearing, there needs to be conversation about is this parent unfit or not. And quite frankly, I have a hard time distinguishing if we have a non-custodial parent who is fit for placement, why are they not fit for custody? But there may be situations out there, but they kind of seem to go hand in hand to me.
I was just going to add, again, the legal stuff, being a case manager, I don't understand all of that, but I would say that the issue that we run into sometimes when we're talking about that custody is their state board. So technically, their state board and the custody is with the department, and so if you have a non-offending parent trying to get that custody, they can't because we have the custody and that has to be relieved first. So a lot of times you have to get these two courts to communicate with each other, and judges and attorneys all agree, and that is very difficult at times, and so that holds that up.
May I just clarify something, or maybe confuse people? If there's a new case that comes in and let's say it's a father who's not offending, and there's no allegations against him, and we come in for the initial hearing, absolutely that father should have possession at a minimum, because there's no evidence otherwise. And under the parental preference doctrine, he should at least have possession. So that's why it's incumbent upon the county attorney, if they think there's a concern, they better put it in the pleading and present some evidence as to why this person shouldn't have possession. That's the first thing I wanted to say. The other thing is, on these cases these custody matters, we typically will take the transfer and just keep it until the case is settled or determined, and then we'll transfer it back for enforcement afterwards. But please remember that when a juvenile judge gets a transferred case, on that case they stand in the shoes of the trial judge where it was originally filed, the district judge. So I can't take judicial notice of what happened in the juvenile court proceedings and decide custody on that custody case. That's a whole new case. Now, if people agree that certain evidence should come in, that's one thing. But just because that case gets transferred to me doesn't mean that everything we did on the juvenile case is admissible. In fact, nothing's admissible until there's agreement or there's evidence presented. I can't take judicial notice of anything that occurred other than the fact that maybe there was a filing. That's about it. And sometimes lawyers think on these custody cases that get transferred that they can go ahead and just have us take judicial notice of what we did in our juvenile docket. No, that's not how it works. So you have to be really careful about it.
Yeah, Gail, before I say what I'm going to say, I want to make sure I understood what you said. You were talking about how the juvenile court judge would not appoint an attorney to represent on the custody issue. Do I understand that correctly?
Correct. I am not aware of any authority for a juvenile court judge to appoint for a custody dispute, because you're not entitled to an attorney to do a custody action. You're entitled to defend against paternity because there's jail time, but you cannot the judge cannot appoint dad or mom an attorney to simply do custody.
So that's absent a transfer.
I think regardless. I think even if it's transferred, it doesn't give the juvenile court any better power than a district court judge.
Well, in Douglas County, I had the case before Judge Johnson. And at the same time, while the juvenile case is running, I established a case with district court, had that case transferred to juvenile court, which allows the juvenile court to act as the district court as well. And in that particular situation, Judge Johnson appointed counsel not once but twice to the mother in this case, who is the party at fault, so that she would be represented in my action for custody.
Absolutely not. I think the county attorney should be challenging that because that's not a proper use of county funds.
Well, there seems to be a lot of differences between counties here and county attorneys. And I guess what I'm suggesting is that if somebody is going to take these issues up to the Supreme Court for clarification on what these terms mean and what the procedures are, they need to do so, because there's a lot going on, and depending upon what county you're in and what court you're in and who the county attorney is, it's all different, and so I think there are some significant issues. But the other thing I wanted to mention is that since we're talking about words and phrases and cases and what they mean, there's a couple of other issues which I would suggest that be included in that discussion. One is that when you have a current protection order, where the court as a district court, is functioning as a district court, and they're making custody determinations, which a district court can make, the typical 90 days you have custody, of the children, and at the end of the 90 days they release that, but that becomes a factor. The other thing that I run into all the time is this, I call it a misunderstanding, is people think when there's a child support order that grants custody. It does not. And there's a lot of confusion, not only amongst attorneys, but a person comes in and says, I have custody. I say, oh, you have a custody order? He says, yeah, I get child support. Not so. So there are a lot of issues, I think, and I think to deal with these piecemeal or separately would be a great disservice. I think these all need to be dealt with for the clarification. Now, when you're talking about the issue of custody versus placement, obviously there's legal custody, and then, you know, they're talking about physical custody, and somehow distinguishing that from placement. You know, I guess it depends what the order says versus where the child is actually living, because there are standards when you're looking at child support as to, you know, how many nights the child is sleeping with whoever it is, you know, that has the physical placement. So there are a lot of issues here, and I think that they all need to be handled together. Otherwise, we're going to get a definition for one, and nobody's going to look at it to see if it's in conflict with the other definition. And the other thing I had a question about, since you were talking about the Sloane case and others, is that if you this whole I've worked cases, I've practiced in at least 4 different states, and some states that if you are a biological parent, you're automatically a party. You do not have to intervene. Now, you may not want to be involved in the life of the child, you know, but you have a right, you know, to be a party just because you're biological. You know, it seems like here, and I've been in Nebraska since 2005, here it just seems like we have to intervene every time if the biological parent was not the parent at fault and wasn't in the home. And I think
That's not true in Sarpy.
Are you doing it county by county?
I'm just telling you in Sarpy County.
Well, no, I know.
If you're a parent,
I practice it in Sarpy,
You
but
don't
I'm saying in Douglas County, you have to intervene.
There's case law. Well, there's also case law in Ray Kiana T. that was a way long time ago. That was a dad. Dad showed up to one of the first hearings, and I was actually GAL, I think, on that case. No, I think I represented Mom on that case. All right. And Mom was there under a filing against her, and I said, by the way, Judge, Dad's in the back row. And so the judge acknowledged that he was there. Guardian ad litem said that's inappropriate, that he has to show that he's dad. You can't just say, I'm dad, and that's enough. So Kiana T. is the one that started, you have to intervene. And I think really the better case law that should have come out, you have to prove that you're father. You can't just, you know, hi, I'm Susie Smith, and I want to be parent of that child. You have to prove that you're parent. It's easier for a mom because there's a birth certificate or a hospital record or something showing this baby came out of her, or there's an adoption record. But for a dad, it's not obvious that you are dad just because you walk forward and say, I'm dad. You can sign, I think now with the change in the paternity statutes, that if you sign an acknowledgement, there should not be any genetic testing. And there's that wheel that's still spinning for whether or not that's true. But I think you have to prove that you're parent to intervene, just like any other case, that you have to prove you have a sincere interest in the case. So that's the only part on that one. The other part that you mentioned, for child support not being in custody, I totally agree with that. I totally agree with the protection order comments. Cass County will file paternity cases against both parents. It's state versus mom versus dad, or dad versus mom. And they will make a determination who has custody and who pays child support, as well as making the paternity determinations. I don't believe mom is entitled to a court-appointed counsel under that one. I won't swear to it, but I don't believe mom is entitled to court-appointed counsel, and I would argue case law and statute does not allow mom to be appointed. Dad is only appointed counsel because he faces potential of jail time. So I guess mom would be entitled if if the allegation she's non-custodial parent. So in that case, you could get both parents to have court-appointed counsel just to determine paternity, and you would have that strange little twist about custody because it's child support. But other than that, I don't think there's any basis for the court to say in a civil case you get court-appointed counsel.
Yeah, I just want to add, because there's a distinction in Sarpy County, it's pretty easy to find out who these fathers are sometimes, because you have to ask the kids when they're removed, who's your dad? They're going to tell you who that person is. They're going to be contacted, and they're going to be included. I don't make them petition or intervene. If we find out later they're not the dad, that's fine. I'm going to err on the side of safety. And the vast majority of these kids identify these people as their fathers when they initially come into the system. They're old enough to say who they are.
And to follow up, I guess, maybe I misinterpret Sloane, but when I read Sloane, I read the court to be saying, if you can show your parent, you don't have to intervene. You don't have to file a formal motion to intervene. You bring the evidence that your parent, you're a party. That's the way that I interpret Sloane. And I would also say that your point is very well taken with regard to how things are handled differently in various counties, because I won't say which counties or which judges, but I have seen where juvenile court attorneys are authorized by the juvenile court judge to file district court proceedings or whatever in the district court cases, just so that we can get to permanency and remove barriers in the juvenile court cases. So it definitely varies across the state how those situations are being handled.
Just to throw one more, I guess, factor into, suppose there is a state line in between this court system and the non-offending parent of an infant who is married to the offending parent, and there's no issue with paternity. What hoops do you go through before you place that child? Do you go through NCIC? How do you handle that?
There's the ICPC, Interstate Compact for Placement of Children. Yes, it would apply if the juvenile court has jurisdiction of the child. So in an ideal world, if the child gets removed from the custodial parent and we can find non-custodial parent, and maybe he's in Colorado or Iowa or wherever, and we have no reason to think he's unfit, we have the joint custody from district court, there's no reason to be concerned about this non-custodial parent that we can see. The only real way to place across state lines is to go to the county attorney and basically say, if this guy comes and gets the child, or this mom, the non-custodial parent comes and gets this child, will you dismiss the case so they can go back to the state where the non-custodial parent resides? Otherwise, if the child continues under the court's jurisdiction, and I think ICPC applies even if it's court jurisdiction, whether they're a ward or not, but as it relates to the department, certainly if they are placed in the custody of the department, we are not going to be able to place that child outside of state lines without following ICPC. Obviously, if the court orders us to do that, we follow the court orders, but we do believe we have to follow ICPC.
And tied with ICPC, generally we do ICPC because you want the receiving state to do some supervision, make sure that kid is not just followed into a hole. I'm curious what will happen if parent comes to Nebraska, judge gives parent custody. As a parent, you can take your child out of state. That's fine. And I don't think that triggers the ICPC because a court is not sending the child. But I'm curious how that's going to impact the ICPC. What do you think on that? If the dad has custody, do you think ICPC still applies? If juvenile court still has jurisdiction?
I couldn't tell if you were looking at the judge or at me. I do think as long as the juvenile court maintains jurisdiction, that because the way I read the ICPC compact is that essentially if there's I can't remember the exact words, but it uses the word jurisdiction. It doesn't use right, and it talks about there being a court with jurisdiction over the child. So I think as long as the juvenile court still has the case open, the ICPC would apply. Judge Gimler was writing me notes on visit, so I'll let him talk about that.
Well, that's okay. You can kind of get around a little bit by authorizing a visit and then go from there.
Yes, under ICPC, a child could go on an out-of-state visit. Those are only supposed to last for 30 days. So if you can get them to go for a visit for 30 days and then get custody changed in district court ruled and then the juvenile court case dismissed in those 30 days, you're a miracle worker. And that would be, then we could obviously close out the case and ICPC wouldn't be an issue.
back to, like, if they come back for a day, can they then go for another 30-day visit, or how does it? I don't know.
Per the compact, no, that doesn't apply, that they will say that's an effort to defeat the ICPC compact, and so there's, part of the funky thing about ICPC too is that it says you shall not and you shall, there's absolutely no hammer. There's no enforcement mechanism, so that's why we have, it's supposed to be done in 30 days and they take 6 months. There's no hammer to do it. They try to all work together because it's mutually beneficial. What we're going to do, sue us? What's going to happen?
We've, in some circumstances, vacated custody with the department, and just placed for a visit, and that's what we put in the order. So you could always arguably bring the department back in if you needed them, and in the meantime, everybody tries to work it out. That's one way to get around it. We just did it with a case in California. We vacated custody with the department, we sent the extra on a visit to California, and then closed the case out eventually that way.
My question through this conversation is the guardian ad litem, the kids, and we talk about placement versus custody. In Sloane, you're talking about a non-custodial parent who there's no reason to place with that child. But if you're going to now fight for custody, you don't know the circumstances where there had been a prior divorce and they had a custodial trial, and the current custodial parent got an order for best interest of the kids. And so just because the offending parent did something to cause the removal, aren't you still geared towards the reasonable efforts to correct that problem that led to the removal, rather than say that the non-custodial parent who hasn't had much contact all of a sudden has a trump card to try to argue for custody? And as the guardian ad litem representing the kids' interests, are we turning this into a custodial battle because of the fact that the juvenile court exercises jurisdiction on an initial removal? And that's the problem that I see in this conversation, is that we're starting to talk about a change in physical custody for on a permanent basis, not just a temporary basis.
And I always have an opinion, so I will start. Sloane did have custody. She had custody at that time. So Sloane actually says custodial parent, no allegation should.
But most of the time what we're talking about here,
right,
it's a non-custodial, non-offending.
Then I think it goes to the judge's issue of you should file that up against both parents, because if you have allegations against a parent, you should make those. And it may be that this parent was found to be unfit by custody, but unless there's a finding of, and a lot of custody orders just read A is fit. It doesn't specifically say and B is unfit. So I think and the burden is on the state to prove unfitness. So if you are a non-custodial parent and child is placed in care due to custodial parent's fault, if state doesn't file anything against non-custodial parent, you cannot assume they're unfit because they didn't have custody. The state has to prove it, and they have to prove it quick. And then I think then you get into the custody versus placement versus custody, custody versus placement.
Well, and I think too, there's a big distinction in my mind between custody in the juvenile court case and permanent custody ordered through the district court custody case or wherever the custody case is pending, whether it's been transferred or not. I see Sloane as speaking to when you have a juvenile court case and the juvenile court has jurisdiction over the child, if there is no reason to deny a parent placement in custody, and the only two reasons available are they've forfeited their right or they're unfit, that parent in the juvenile court case should have placement in custody. And there's nothing that says that once you, and this is up for debate still, but there's nothing that says once custody goes back to the parent that the juvenile case must necessarily close. I would argue that the department would probably not be involved in the juvenile case anymore, but the juvenile court can still maintain jurisdiction. The offending parent can still be ordered to do things if the juvenile court still has jurisdiction. What I've been talking about custody today, I'm not really talking about going to district court and getting that permanent custody changed. I'm talking about in the juvenile court case, where should custody lie? With the department or with a non-custodial parent or with the custodial parent? And that's what I've been referencing.
I don't want to make this too complicated. There's a lot of responsibility on a county attorney when a case first comes in to make sure that those folks who are investigating this case have investigated it thoroughly. If you have a non-offending parent in the juvenile court case having lost custody because of a dispute in another court, the county attorney needs to allege something in a petition as to why that non-offending parent on the juvenile court case should still not get placement. And I will sometimes, at initial hearings, get copies of the decrees from Iowa, for example. Just recently we had one, where custody was granted to mother, and mother is now the offending parent. The non-offending parent. Because the state didn't want mother to get possession of this child. Father was granted custody, and they didn't want father to have possession. Mother to have possession because father was the offending parent. I don't mean to confuse you. So they introduced the decree as part of the proceeding, and in the petition, it alleged that the mother should not have, because the child was endangered because of the circumstances that the mother, proved against the father, for example, in another state. And that's not hard to find. Those are fairly easy things to find. You can interview the mother and find out the circumstances, interview the father, talk to the child. So I think it's really important that the county attorney file these things initially and include all the parents and make those allegations clear. The thing that perplexes me, and I just want to throw this out to all of you, under the old juvenile code, and I'm talking about in the mid-70s through about mid-80s when it was revised, a reputable resident of the county could be a petitioner in a juvenile court action. You didn't have to be the county attorney. And I'm wondering if these rules give you some latitude to file something supplementally, and perhaps maybe they should. So that if somebody hasn't done their job as a county attorney, as guardian ad litem, it seems to me you ought to be able to come into court and file some sort of pleading in an effort to protect that child. I don't know if these rules provide you that latitude. You're welcome to try it. But that's a piece to me that I find very concerning, is you have all these responsibilities and you have all these obligations to the system, and your role has greatly increased. And as I said, the responsibilities now, I think, are huge. There's a lot of expectations that are placed on all of you. You ought to be able to go into a court system and say, look, the county attorney hasn't alleged this, but this is what my findings show, and Judge, I need you to do something to protect this child. And I'd like to think these rules provide you that opportunity. I'm not sure if it clearly does, but that's my biggest concern out of all this discussion is you have all these responsibilities. You're supposed to do all these things, but if the county attorney doesn't make these allegations, are your hands tied? Is that really fair to you as a guardian ad litem? I don't think it is.
And 2 points, one tied with that one and one to answer your question that didn't finish it. You're talking about reasonable efforts. If I remember the statute correctly, it's reasonable efforts to achieve the permanency goal, and it's presumed to be reunification unless it's specifically something else. It doesn't say correct the problem that came into juvenile court. So if they say, then there's always the issue of, we've got two parents. If you place with non-custodial parent, that may still be reunification because the child is with a parent and they are with their home. So there's that argument that is reasonable efforts if trying to place with the non-custodial parent. And with the judge's comments, the old rules, and I haven't looked at the new rules in relation to whether or not it applies, but under the statutory scheme, a guardian ad litem definitely can file a supplemental petition. There's In re Valentine that talks about no one else has authority but for the county attorney to do the initial petition. And I'm not sure if it requires it to be adjudicated before somebody else can file a supplemental. That's the only part I'm not sure on. But you definitely, as guardian ad litem, can file a supplemental petition at any point, definitely after adjudication. I'm just not sure if you can do it before adjudication.
And the department and I disagree, but I think the department can also file a termination anytime that it wants to, once that initial petition is on file. It says any party, and it talks about HHS specifically can file any kind of pleading. But at Guardians Litem specifically, we're given the authority to file anything that the Guardian Litem deems appropriate under the original statutes.
We've got another question from the web, and then I'll come over to you, Duke.
Actually, Neil said what I was going to say.
Oh,
so-
perfect. This one goes back to the best interest analysis. The question is, can you even get to a best interest analysis if there are no allegations against a parent? So I'm going to ask again, on what grounds would you not give the non-offending parent temporary custody rather than just placement?
I think, because I'll always answer. I think best interest is always the standard, so even with placement, you're looking at best interest. So I think there is that best interest element even on a placement. There may be a reason, and it's just kind of the never say never, and it depends analysis of an attorney. There may be a reason why you want to give the department custody and non-offending person placement. For instance, the non-offending parent may want to do essentially a voluntary case, and we have that ongoing issue of the department will not pay for services, but if the child is not a state ward. So it may be essentially for the non-offending parent a no-fault situation where I need this service from my child, easy answers therapy, that I cannot pay for, so I am going to allow the child to be a state ward even though the placement is with me. So I can see a situation where you would not, where I as parent's attorney would not want legal custody, but I'd want placement. And I do think best interest plays in from, at the time the petition's filed on, frankly.
While she's getting her train of thought, I just want to add one other comment. The genesis of this parental preference thing really goes back to guardianships and probate guardianships. And the idea was that if you couldn't prove that that parent was unfit, that guardianship could not be established or it had to be extinguished. Best interest didn't matter. And quite frankly, I think that's the law they apply on these juvenile cases as well. Parental preference doesn't discuss best interests. That's why I think it's incredibly important that a county attorney files something in a pleading to protect that child, even if it's a no fault. Because if the pleading is silent, when you go back to read the case law and you read the definition of parental preference, its genesis are those guardianship cases. And there's no issue or discussion about best interests. It's not part of that discussion at all.
I agree with what the judge said, and I remembered what I was going to say, is that, under the parental preference doctrine, it's whether or not the parent is unfit. It's not whether or not there are allegations in the current juvenile case against that parent. So there could be a circumstance where a parent is completely unfit to have custody and or placement of a child, but where they don't include those allegations in a juvenile court petition. And I don't think the fact that there is no filing on that parent necessarily means they're automatically fit for placement, but I do think it makes the argument a lot more difficult. But that's what you have a temp custody hearing for. The state has the opportunity then to explain why it is that they don't think that this that the non-custodial parent should have custody. But I don't necessarily, to me, it's not necessarily there's allegations in the juvenile petition or there's not. I think you can argue on fitness aside from allegations.
My little comment is that Maya may answer that for us, because I think Maya was saying that Dad, since a judge gave Dad stuff that Dad needed to do in order to get placement, there was the Court of Appeals decision, if I remember it correctly, said there was a showing of unfitness. So there wasn't a filing, but there is a showing of unfitness. So I think that goes to Neely's point. But I think with Sloane, that I'll be curious what the Supreme's do with it.
There is a filing in Maya. It's a supplemental petition against the dad.
It's unadjudicated.
It's unadjudicated, right.
Well, and kind of going to that, is it automatic assumption of the parental, preference doctrine? So why in Ray Sloane do you think that the case was remanded and not, why did they get another kind of bite at the apple there? Or did they get another, was that, was that the appropriate?
My 2 cents is because the Supremes it's been a year, and so they don't know if there's something else that if mom is actually crazy and they just found that out. So I think the Supremes were essentially taking a cautious, this is a new decision, and so they didn't want to say, and here now the child is totally hosed. So I think it was kind of a protective thing. It's much like the Supreme Courts won't decide, they won't change the protection laws until the protection order is basically expired. I think it was kind of the same analysis, and that's why they remanded it to say, let's since that was not the standard before, let's make it clear it is the standard, and state either step up or shut up.
I think they were hedging their bets.
Karen thinks they were hedging their bets. Oh, here.
Okay, so here's the fact pattern that comes up in 99% of my cases, where there's a non-offending dad that comes in and gets placement before the case closes. Let's say everyone's still involved and we're very close to actually reunifying with mom. Then who wins at that point? Because we have placement with dad. We have the department still involved. We have mom who's worked services and worked her tail off to get to a certain point, and a dad that just kind of comes in at the 9th hour and says, I get placement, and we respect that, and we put the child with them. Then is it best interest?
I think if nothing is filed for the 2 things, the favorite attorney answer, it depends. It's going to be very case specific for what is in the child's best interest. But I think unless there is a filing asking for custody to change, if mom has successfully completed the case, jurisdiction terminates and she gets custody back. Unless there's a filing, I think that custody order trumps.
So I've heard that the NFC policy is that once the child is placed with the other parent and there's nothing filed, NFC needs something akin to a removal, so a safety concern, to go back to the other parent. I don't know if that's true, because it's just what I've heard.
I'm sure Monica can talk too, but there's no, I would say policy. If a child is with non-offending, whatever, non-custodial parent, and it's in the court's jurisdiction, that is up to the courts. So if the court says that we're placing back with mom or custodial, if that's dad, whatever, we place back with them. If they're with the other parent, so that decision a lot of time is made into the court's decision. If they're with a father and we're ordered to give a mom reasonable efforts, that's what we do. And ideally, from my perception is that we're working so both parents can be suitable to co-parent these children. I know that normally doesn't happen, but that is what we would like to see. So are you talking like after it closes or while it's open? I don't necessarily think there is a policy. Our policy is that we place with a non-offending parent if they're deemed appropriate or fit. But if the courts deem us or want us to work towards rehabilitative efforts toward the other parent, we do that. I don't know if Monica could say different, but I don't think there's anything that states that we can't reunify with that other child parent.
Is there policy or practice as far as to guide your recommendations to the court when they're asking you, how to go forward?
If there's a suitable parent and they are deemed appropriate and suitable, obviously at that point our primary goal is family preservation. That child is with a suitable parent. That doesn't mean we won't work with the other parent, and normally we're court ordered to work with the other parent. However, if they're placed with a suitable parent, that's family preservation, and that is our main goal.
For both HHS and NFC, are there any policies or standards that go towards kind of that co-parenting goal. I think that the panel touched on at the beginning, like obviously the best interest for youth is to have as many loving, interested adults in their lives. Are there any guidance as far as reaching that co-parenting goal?
I don't know if we call it co-parenting or identify it as a co-parenting goal. I mean, obviously there's the policies that are included with the handouts where the department and NFC are to look at non-custodial parents as the first placement object or preference, and to the extent that there isn't a father identified, we should be looking to identify that father from the very beginning, because like you said, it is best for these children to have both parents to the extent possible involved in their lives. And most of the time, in my experience anyway, is that if there are two parents identified, a lot of the case plans are going to identify goals and services that will be provided to both parents. So I think that we are working towards co-parenting. Yeah.
You don't need, I can. It's a two-part question. First one, is there agreement that placement with the non-alleged offending parent is not automatic? And does there have to be some determination of best interests?
Well, I'll just try and answer this question. I may have said it earlier, but if there is a new case that comes in, mother is accused of wrongdoing, there's no allegation against the father at all, it's the initial hearing, father gets the child. Parental preference just applies, period, and we cannot consider best interest because best interest isn't part of it. That's why I think it's really important that there be some sort of pleading that regarding the non-offending parent as to why that child maybe shouldn't be placed there. Or maybe the guardian ad litem should be filing a supplemental pleading if that's permissible. I wish it was clear in the rules, but under parental preference, if there's nothing alleged, and that's an initial hearing, that father, who's the non-offending parent, just gets possession.
So placement, not custody.
Well, for my purposes, I'd have a hard time arguing why that case should continue. It doesn't happen in our county because there's going to be a pleading against the father, even if it's a no fault. And it may allege that it's not in the best interest for the child to be placed with the father immediately because of school issues or lack of contact. There's going to be something in there that allows me to be a little more careful, at least where we practice.
Why not custody?
I think you could.
Thank you.
Yeah, I do. But I'm just saying in our jurisdiction, typically, there's always something filed on the non-offending parent. It may be alleged through no fault, but my point is, if there's nothing alleged, nothing pled, best interest doesn't apply, parental preference applies, and that father would get custody. And I don't know why the case would continue with that. If that makes sense.
I think it would only have to continue if dad was not the custodial parent as well, just to get the custody.
I understand that, but there.
I understand what you're saying too.
Yeah.
Why were we taking
Why are we
such a
here?
short time?
Yeah. I didn't mean to confuse anybody.
I stand by my proposition that you could argue unfitness at the temp custody case, whether there are allegations in the juvenile petition or not.
The issue I have with that is how does that parent defend themselves? There's no notice to them. They have no idea how they're supposed to present their case. I just can't put them in that position.
What do you mean they have no notice? Sorry.
Well, they show up at a hearing and there's no allegation against them. There's no evidence of wrongdoing. There's no allegation that the child is afraid or has special needs. So that parent comes in and all these things are being alleged. There's nothing in the pleading. I don't know how they defend themselves. I think that's a violation of the due process.
Yeah, it's basic due process that you have to have notice of something before something can be taken from you, including custody. So if you're not on any notice, when you file a divorce action, you're giving notice that you're asking for custody. When you file a custody action, you're giving notice that somebody's asking for custody taken from you. Juvenile court's the same thing. If you're given notice that something's being taken from you, and if there's no allegations against you, you shouldn't assume that means, and you're gonna have to prove yourself good against something that we're not gonna tell you about until you show up. That's not due process.
I guess I would say that the non-custodial parent, if they're actually at court and they have their attorney with them, they've gotten a copy of the pleadings, they've seen the temp custody motion, they've seen the temp custody order, and it brings me back to the burden's not on them. The burden's on the state. And I understand the practicality is that if something is presented against them, they're going to have to be able to rebut that. But I do think that they have a certain extent of notice as to the proceedings and the custody issues that are going to be discussed at that case. And the fact that they don't have custody or placement of their child already would also, I think, put them on notice, wouldn't it?
No, I think not having custody does not put you on notice that you're unfit. And unless there has been there has been a filing that you're unfit. But if there's been no filing or you have a custody order, it does not say you're unfit, it just says mom is fit, for instance. I don't think that gives dad notice that in a temporary custody that his fitness is going to be questioned. And if it's in the affidavits that said, and we're not placing with dad because he's unfit, that should be in the pleading as well so he can defend against it. Because an allegation in an affidavit I don't think would rise to the level of due process that he has been formally given an opportunity to defend against it, because then you're entitled to specifics, time frames. Mom says that dad's a bad guy, so what does that mean? Can I strike on that? Is that too vague? Has anything been alleged against me?
And if the dad's not listed, or he's not listed in a petition, he's not going to get a sent a copy, he's not going to be served with anything, he's not going to be,
But even if he's listed, if there's no allegation,
yeah.
So, and you touched on the In re Maya decision then. So in that case, the dad was a party, but before he was filed on for not following the court orders, he was obviously ordered to complete, I believe, a batterers or intervention case, but that wasn't related to the original adjudication against mom. So how does that fit in that he can be ordered to do that if he wasn't filed on for that?
well, I obviously don't know the facts of that case, but again, I can only relate it to our county. We would voluntarily offer those things to him if he wished to participate. But I wouldn't be able to court order him to do anything because there's no allegation against him. Which I go back to again, why it's important that either something be filed on that person, or then the presumption is they should just get custody. There's no allegation.
Judge, my question is it full legal and physical custody you're referring to? Good.
Well, again, our orders are always only temporary.
Okay.
Because once our jurisdiction ends, our orders cease.
Okay. That makes, okay, my other question is, post-adjudication, that comes in one's custody. Even under the parental preference doctrine, doesn't best interest count at that point? Because you have more facts about the child, you know what's going on. That shows up post-adjudication. Do we still give parental preference doctrine?
My answer would be yes, because under the case law, again, parental preference goes back to guardianships, probate guardianships. Best interest isn't an issue. It's whether or not parental preference applies, which is, again, why if there's no allegation pending or nothing alleged that makes it concerning, then that parent just gets custody.
So at that
albeit
point,
it's temporary because our orders are always temporary.
So at that point, the GAL has to step in.
Exactly.
Okay.
Yeah. So there was a question somewhere. Was it Karen?
Yeah. It was really more a comment. Comment, Mike.
Yeah. Case law requires that at the beginning of a case, both parents be served via summons a copy of the petition. That never happened in the original Sloane O case. And I don't think it consistently happens. And so I guess the reason why I'm bringing it up, and I think additional training, whatever, and I did raise that as an issue in appeal, and I'd have to go back and refresh my memory on how Sloane O addressed that. But there was case law that I cited that said, look, because the father, the non-offending father in case that I had cited had never been appropriately served, the adjudication on the mother needs to be vacated and the whole case reversed. And so I think that practitioners, county attorneys need to be very careful and very alert to make sure we're identifying both parents at the beginning, we're serving both parents at the beginning, you know, whether it's the original petition, it's an amended petition, it's a supplemental petition, and that we're following the rules.
I can just make one comment, because you're really good at this. You always make me think when you come into our system, which is good. One of the first things I learned from Judge Nurnberger, who was a fantastic man, was as a judge, get people to waive reading a notice. So all of you who come into my court at the initial hearing, I will always ask the attorneys, do you waive reading a notice? So that no longer becomes an issue. Because if it's not waived, you're absolutely right. Absolutely right. And I think that's something that county attorney, if I were county attorney, I would ask it of everybody that was present at that initial hearing. If the judge doesn't, will you waive reading a notice?
And in Sloane O, the mom was an active initial.
I know.
And it became
I agree completely. But that's why I always ask, do you waive reading a notice? Thank you, Judge Nurnberger, really. If anybody doesn't know, he was the first juvenile court judge in the state of Nebraska, and a wonderful man in Lancaster County.
My question has to do with the notice. Let's say you've got a case where the father was noticed, mother has custody, the child becomes a state ward, and there was no allegations against the father in the initial pleadings. The court takes judicial notice of the guardian ad litem report and the court report, where within those documents, allegations are made against the father. Is that sufficient, or do we still need to provide a supplemental petition?
What did the allegations say?
That the father was unfit due to his use of marijuana, his home is unsafe.
And then is there some evidence, and then there's evidence presented for probable cause purposes to show that?
Yes.
Well, that helps make a difference, yeah.
Okay.
My little twitch, what you just said, that there was taken judicial notice of the guardian ad litem report and the case plan and court report, that's completely bad practice in my opinion. That's not evidence. The judge can't take, well, it's evidence, it's just bad evidence. The judge can't take judicial notice of disputed facts and should not take judicial notice, I would argue, of any report. It should be offered and received, and if it's received, then it's evidence. And then that's evidence of unfitness, which I think is what Maya is going to help us decide, that if there's evidence of unfitness, is that enough, or does there actually have to be a filing? I would be interested if that was raised. I'll have to ask the attorney on it, if she raised that as a due process issue. Because if it's just raised, that's still not notice necessarily, because you don't have advance notice of it. And even if you received an advance copy, that's different than a true pleading where you have an opportunity to defend. And you have some counties that do, unless somebody specifically asks for a hearing, there shall not be one. So do you have to specifically ask for a hearing in order to defend yourself? I think that's a huge due process issue. But it makes me twitch every time somebody says, take judicial notice of an affidavit, take judicial notice, because that only means the judge should say, yep, there's an affidavit. I have no idea what it says, but yep, there's an affidavit.
Thank you.
Well, just even when you're taking judicial notice of something else, you should make sure it's marked as an exhibit and part of the record. Like I've been asked to take judicial notice of prior pleadings on prior cases, which I can do, but somebody better make sure that what they want me to take judicial notice of is marked as an exhibit. Otherwise, I can't. It's not going to be in the record.
I just wanted to add one thing too. I feel like if a case manager and in Douglas and Sarpy County, a family permanency specialist is saying a parent is unfit, they need to be talking to the county attorney to file that. Yes, the county attorney does need to file it, but I would feel that that is our job to communicate that. How would they know that if we did not? I mean, just because it's in our court report doesn't mean that we have communicated with them to file it and given them what they need to file it. my point of view as a supervisor, if that was happening with one of my staff, I would tell them that they need to contact the county attorney. We would probably write an affidavit and provide the evidence that we have. We can't just say John is using marijuana. What proof do we have? We need that so that they can prove that up in court. Otherwise, if they go in front of a judge and we're like, well, we think he uses marijuana, that's not going to stick anyway. So, but I feel like a lot of that, it is on the county attorney, but it's our job to gather the evidence to help the county attorney file that.
If any of you in your experience, are there any services out there that you've utilized or know about it that could assist if a child is going from the custodial home to the non-custodial home, ways to minimize any of that trauma or any ways to help engage both parents, things that would be helpful for guardian litem to possibly recommend to the court in such situations?
A lot of times I would say use the evidence-based practices. There's a lot of therapies that help parent and children build bonds. You hear a lot of them, the Safe Start assessments, the child-parent psychotherapy, the PCIT, a lot of those things can be recommended to help them connect. I guess, too, that it is important what the child says, and I know that it is parental rights, but switching, sometimes it has to be done, but switching schools and environments is very hard for children, so making sure that they have the supports they need. But there's a lot of evidence-based therapy and practices out there that I personally would recommend over just other things.
This is just my opinion. I think sometimes we over-evaluate people, like on fishing expeditions, trying to find something wrong. And those are expensive, they're intrusive, and they're, I think, frequently unnecessary. So I think one of the better approaches really is to allow people just to go to a therapist and see if there's recommendations that come out as a result of those sessions. Maybe a parent will need a chemical dependency evaluation or a mental status evaluation, or maybe that child might need something. But to order all these evaluations at the outset, it delays things. And I feel like we're going on fishing expeditions, and I just think it's unfair, particularly, actually even to an offending parent sometimes. Give them an opportunity to visit with a therapist and a clinician in a private setting and see what that clinician recommends. We can do a CPP assessment and see if we need CPP. We can do a trauma assessment, a screen, to see if we need to be further involved because of the trauma issues. But we don't need to order everything all at once. The other concern I have is we don't want to overwhelm people. I mean, the system is overwhelming enough. Most people that walk through those courtroom doors don't trust us because they've heard of experiences with other people or in their family where they were treated unfairly. And they just don't trust the system. And quite frankly, I don't blame them. So I think it's incumbent upon us, and really upon me too, to make sure the tone is set that we're not going to invade and make you eat an elephant in one bite. This didn't occur overnight. It's not going to be fixed overnight, but we're going to make things better for you. And we're not going to have you jump through all of these hoops. It's just, we got to be careful about that. So from my perspective, just giving them a chance to meet with a clinician that everybody trusts and have that clinician report back with some recommendations is probably the best way to handle it. And assure some of these folks that not everything they say in these sessions is going to be reported back to us. I don't need to know all the details. I don't want the attorneys to know all the details. Sometimes people just need some privacy, and I think we have to respect it. And then at that point, we can decide where we go next.
We can go back to our list of questions. I guess for the panelists, are there any questions that we kind of talked about before that you really wanted to make sure that we covered that we haven't yet? Does anything jump out to anyone?
May I just say one other thing? Sometimes parents are separated by distance, and we, at a minimum, try and include them by phone. Even if a parent's in the penitentiary, we'll try and include them by phone. And I've had for example, a parent who was in the penitentiary when mom did something wrong, so they're not in the penitentiary because of child abuse, it's something else. We still try and include him by phone. He's now out now and he's come to court, and quite frankly, I'm hoping that he continues to do well because he may be this child's best hope. But the more these folks feel included, despite their distance, I think the more likely we are to get a better result. If we can include them by Skype, sometimes I do. And all of you know, I'm not telling you that you don't already know, a lot of these folks don't have access to Skype, they don't have access to internet. They have access to a phone, hopefully. But I just think doing some of those small things and making sure they're included and can participate by phone just makes a huge difference. From my perspective, I worry about what they think if they're not included. And as I mentioned, even these people that are in the penitentiary. Just had a case this week where the guy got out, he came to court for the first time, we included him 3 times by phone. And I'm really hoping he does well. And I hope he trusts us, actually. So we'll see.
For other things to think about too is going to be what's going to happen with the dangling dads, where it's a baby, and so we don't know who dad is. Mom is cagey about identifying who it is because she says he's a bad guy, so doesn't want him involved, or she thinks he's a good guy and doesn't want him to get custody. So, you know, how can we identify the dad early on? Because I think the My King case talks about dad was not identified until after the child had been in care for a significant period of time, well, at least for several months. So, you know, do we file against John Doe at adjudication saying John Doe doesn't exist and or hasn't been identified, and so therefore the child's in need of a parent, so that there can be some kind of active effort to or something more than just, hey, is there anybody who says that they're dad?
We actually did file on John Doe parents, and then
You want to?
yeah.
Yeah.
Go ahead.
Getting my steps in.
I was going to say, when I was a prosecutor in Sarpy County, we actually did file on John Doe dads.
An adjudication or what?
In the original petition. And then if somebody comes up later, says they are the dad and they can show it, they're just automatically, and you should put all that on the record, they're automatically a party because they're the parent.
But my question is, if it's John Doe, and so we're at 1522, and now we know John Doe is actually John Smith, is the answer, sorry, you're hosed because you were adjudicated as John Doe, and the fact that we're now changing your name, you should have been in this case from the get-go, because that's, to me, is the problem.
No.
Yeah, that doesn't take care of that problem. You still have the same problem that dad comes in at 1522. Dad gets a whole new set of issues, or a whole new set of efforts if there's any problems with dad, right?
That's why I think it's a responsibility of the system to try and find out who that person is on day one. I mean, at the initial hearing, I want to know who's the dad or who may be the dad, and everybody in that room who is advocating for that child has a responsibility to find out who that person is. And typically, we can find them. It's rare when 15 months out, we don't know who the person is. And at that point, if we don't, it's John Doe. And one of the reasons we do the John Doe thing and still do it is because if we terminate parental rights, we don't want an adoption occurring where now the adoption attorney has to worry about terminating on whoever dad may be. That case is closed, it's clean, and that child can be adopted.
Hey, Judge, this is geared towards early closure again. When we close early, I worry about, for example, my clients who need the help. I sometimes want the department involved so they can get services. Most of the time they can't pay for it. But when we have those custody cases, the Sloane cases where they come in and the case closes out, where does that leave clients like the offending parent who needs the help, but when dad comes in, takes the kid, the department is relieved, that parent doesn't get the help. I've always thought the institutional competence of juvenile court was the time we have to make sure these folks get the help they need. With Sloane, we really don't get that anymore. Those parents are left in the cold. I have clients that's has addiction issues that needs treatment but can't pay for it, needs resources that the Department of NFC can offer. When we close out early because of Sloane, they don't get those services. What happens?
Great question. Your client has a right to be heard. And maybe the court needs to take into consideration those issues and come up with some solution. Juvenile court's a pretty flexible forum. There are a lot of things that we can do. And so in that circumstance, maybe we can stay involved for the benefit of your client, but make it very clear that the other parent has custody. But in your circumstance, as to your custody, it's with the department. I mean, there are some creative things that we can do that I think try to address those issues. But it's a great question, because I think on the other side of it, they can come in and just say, we don't want to be part of this. I don't know if I answered your question.
And I think, in my 2 cents as well, would be that's the whole problem with our system anyway, dealing with mental health and people with substance abuse. There are a lot of people who need treatment that do not get it and that cannot afford it. So that's a societal problem. I don't think it's up to juvenile court to fix it. In that, juvenile court is supposed to fix the situation for the child. The situation for the child is fixed. It's better if the child has 2 fit parents. It's better for society if everybody is getting their mental health or their drug addiction issues treated. So I think that, to me, the issue is more society needs to step up on treatment for these people with these issues. It should not necessarily be tied to juvenile court. Juvenile court can't fix everything.
To what extent could, once a case closes, could the parent ask HHS or NFC to remain involved?
I mean, we do have services, we have aftercare, but those services are usually not like financially responsible. They're more of helping them navigate community resources, and those community resources are difficult. Lots of times there's wait lists, and when you're suffering with a mental health problem or a substance abuse, waiting 3-4 months on a wait list is detrimental, and I understand that. And sometimes the sliding scale fee, why it is not, like if somebody told me, yeah, you have to pay $10 per time, may not be a big deal to me, but it's a very big deal to them. It's food and water on the table, food and milk on the table, whatever. But our aftercare job or whatever non-court job is really to help them learn how to use those community resources to their advantage so that they aren't dependent on us. So that's really our focus. And I usually try really hard before we close a case in court or recommend that they're not depending on us anymore, that we're not paying for therapy, that we're not paying, so they've gotten themselves to a position that they can pay the $10 a week for therapy, or they can pay for their meds, whatever that is, $20 or whatever. Because if they are still relying on us to pay that, we should not be asking for the case to close, because what's going to happen, the case is going to close, they're not going to take their meds, and they're not going to go to therapy, and they're going to re-enter.
At least from my perspective, most people want to try and do the right thing. And in many circumstances, the parent that has custody is willing to give the offending parent a chance to rehabilitate a little bit, because it's the benefit of everybody, really. That most people in the system are trying to do the right thing, from my perspective. They just struggle with it. So I typically think there's a remedy for almost everything. That's just me.
Karen walked out. I was going to call on her, but in the case, there were 4 issues on appeal, 2 that they reached, 2 issues. Whoa, sorry. I'm so sorry.
Mics are too close to each other.
One, that the underlying adjudication was improper because she was not served, and also improper because there weren't any allegations against her, I think. And they said they didn't reach those because they were untimely. In your opinion, how do you think the court would have addressed those issues had they reached the merits of those? That the underlying adjudication was improper because she didn't have service, and also because there were no allegations against her.
Yeah, we'll let Karen do that. On the issue of it not being timely, I think the other, I don't know how they would address it, obviously, but you have a situation where a parent cannot be found, and usually it's an emergency situation. So if it's a situation where the parent is not in the picture or unidentified, I don't think it can be a ground to say you have to get both parents served or you don't have jurisdiction. I think that's going to be a problem anyway. But on this one, she was definitely findable, and she was a known quantity, and they should have served it. I think that goes to the judge's comments of, does everybody waive? And I think that's better practice. If they are not waived, does it have jurisdiction? I think there's an argument they may have jurisdiction up until mom comes forth or mom says I was not served. So it may be essentially you have to raise it before I can address it kind of answer. That's my guess.
I think if you don't have service, you don't have jurisdiction.
What do you do if there's
Then you got to publish notice. That's why we have the John Doe, and then we publish notice. So, but my personal opinion is you've got to have notice, or if you don't have notice, you can't acquire jurisdiction.
So we were discussing the two issues you raised on appeal that they did not reach because they said they were untimely, even though she didn't have service, she still to be at the adjudication and know of the order to file it in time. But kind of what was, if they had reached the merits, we were kind of talking about how we thought they would have decided, and also some of the issues surrounding those two issues.
It was actually,
Yeah, and I'll give you the microphone.
Procedurally, it was actually very interesting. I had filed the motion for custody, I think, in October, and got a hearing date for the same date as the trial. So we went first, and then the judge gave us a whole briefing schedule. And then, so that I think was November 14th or November 13th of 2014. And the second part of the trial was supposed to be mid-November. And then Judge Johnson expedited the rest of the adjudication. And so he heard it, I think, November 2nd of 2014. And immediately thereafter issued an adjudication order. And then the dad appealed that. So that's why there was 2 dockets on the appeal. And so then the judge took a long time in issuing an order after the briefing schedule, and then determined that because the mother was not a party, that he wasn't going to make a decision on the motion for custody. And then the mother took a while deciding whether she wanted to appeal that or not. So we got our decision, we appealed our decision like on day 28 or something. So that's why the court determined that we had untimely appealed because it was spread out enough that I think had we gotten our appeal in like on day 4, we could have done that. But so I don't know what they would have done had they said it would have been timely appealed, but I think it would have been a more fascinating decision. But I think essentially they might have just came back and said it's all moot anyway because we're reversing and remanding it. I don't know. It might have been more fascinating if they came back and said, yep, we're going to boot the adjudication too. But I think they were looking for a way around that. But I don't know.
I just want to know before we everyone can give their closing remarks too. We talked a bit about the rules for guardian ad litems, and I think you're aware that there's some legislation this year that's not just picking on guardian ad litems, but saying all attorneys who practice in juvenile court need to have some standards of practice and training too, because we've talked a lot about things county attorneys should do, things that defense counsel should do, and stuff like that. So I want you to all know that that's something that's coming up and something that'll be discussed too. That everyone, it's a specialized practice, and guardian ad litems and everyone need to have some specialized training because these are kids we're working with. So I'm just going to kind of open it up to the panel to give any last remarks. If got anything left in the tank after this panel, and thank you again to everyone for coming. So.
I would just say thank you again for everyone for coming, and thank you for everyone participating in the discussion. I think juvenile court is just a fascinating area of law, and it's such a evolving situation that it every time there's an answer, there's 50 more questions that come up. So thank you all for being a part of it.
I guess same thing, echo, just thanks for being a part of it. And as far as the legal stuff, like I said, a lot of times case managers don't understand all of that, this stuff, but I'm sure if you have any questions or concerns about policies and stuff, you can always just contact Monica or Neely sitting here, that they would answer a lot of those things. And I guess know too that a lot of the case managers, as you guys probably know, are young and they don't know all the rules and expectations. So sometimes they probably just need a little bit of guidance and suggestion, or maybe contacting their supervisors so that they get the appropriate training. So I guess really all I have with that is if you're having issues, make sure that you let us know so that we can make sure that we're working with our staff so they can be trained appropriately.
I don't really have anything else to say that hasn't been said, so thank you. Thanks for listening to my thoughts on things.
And we do have one more question coming away.
This is for Judge. It says under the parental placement doctrine, and even though it is applied to cases under the juvenile code where best interest does control, in a case where the county attorney has failed, neglected, or simply did not know of reasons a child should not have been placed, this is a long one, with the parent against whom no allegations have been made, must the court make placement and wait and see if harm befalls a child before acting? And then there should not the court order some investigation before placement is made in juvenile court?
Well, the answer to the second question is yes, but I cannot insert myself in these proceedings. I mean, I have to be very careful about that, so I can't tell people what to do. But under the parental preference doctrine, best interest is not an issue. If there are no allegations against a parent, I think under the law, the parent gets custody. So that's why it's really important that everybody do this research in advance, and at the time of the initial hearing at least, have an allegation and present some evidence. And that's why I suggest, I think these rules recognize your importance in the system. I think you're incredibly important to the system. And I think you have some additional opportunities, not only responsibilities, but opportunities. So that's why I said here earlier why I think maybe you could file something. If the county attorney's not doing his or her job, and you think that there is danger looming for that child under the parental preference doctrine as it's applied, then I think it's incumbent upon you to file something. That's the only way I can answer it. But best interest is not part of the parental preference doctrine at all. Yeah.
On the question you mentioned earlier, and let's you all were talking about it while I was out of the room for a minute. You talked about that if the county attorney is not taking action on something, that somebody else can file it. In this case, we're talking part about the guardian ad litem. But does that also go as far, there seems to be a policy, quote unquote, both of NFC and of the state not to follow 15 out of the last 22 in terms of filing TPR. Even when it's very much warranted and there's all kinds of evidence for it, it seems to be discretionary. Can a guardian ad litem or, let's say, an attorney representing one of the parties, can they file for TPR?
I think you can.
As what?
Guardian ad litem.
As a guardian ad litem? Yeah. But not as a attorney, let's say, for a parent. Against the other parent.
You might be able to, I think.
I don't think it's been done, but I think you can.
Yeah.
You can file it as different in district court, you can file for it.
Yeah, absolutely. Yeah.
You can restate, or
Oh, I'm sorry. The question was whether or not a guardian ad litem could file a pleading to terminate parental rights, a supplemental or a motion, and whether or not another party to the action could file a pleading to terminate parental rights. I think the answer is yes.
And for the record.
Oh, it's for the record. You're going to need the microphone.
I think you might be giving the department a bit of a bad rap because the department did contract with me to go in a small county, and Gail can vouch for this, to terminate parental rights in a case.
HHS current position is that they do not have authority to file terminations at this point, despite the history that they have done it, and I've done it as HHS legal, and several other people have done it. But the current policy, do you want to jump in, Neely, before I add that?
It was like, the current legal position of HHS is that we cannot initiate the termination of parental rights petition. So you will not see HHS attorneys filing those motions for TPR. However, the question was specific to like 15 out of 22. What we could do is file a motion for an exception hearing if the court hasn't had the exception hearing that is required for the 15 out of 22 to establish whether or not the county attorney has a duty to file the TPR, or if there is an exception that would prevent the county attorney from having to file the TPR.
So it would be a motion to file an exception?
It's an exception hearing. Under the statutes, once they've reached 15 out of 22, you're supposed to file a motion to terminate. However, there are 3 statutory exceptions to that. And then there's the statute that sets out the exceptions, and then the statute right below it says that within 30 days of reaching the 15 out of 22, the court shall hold a hearing to determine whether or not an exception exists. And I know from the department's data, and I know from some work that the Foster Care Review Office has done, that there's some question about how frequently these exception hearings are actually occurring across the state, not just in any one jurisdiction. And so we're trying to take some active steps to ensure that those hearings are occurring. Sometimes it's not to spur a TPR. Sometimes there's a legitimate exception, but we just want to make sure that we have good documentation to show why aren't we moving forward with a TPR.
Well, the reason I was given, as a attorney for a parent who had no offending behaviors against him, and who will vis-a-vis, custody hearing with the juvenile court acting as a district court, why he will have the child, is because it was stated that because there is a biological parent who will assume custody, that there was no reason to file against the mother. However, the mother, in my opinion, is a danger to the child, and if any way, shape, or form, she gets any visitation or contact with the child later, it could present, an issue. So right now, she's not excluded, from having contact, or other rights, because she'll never be terminated. And I guess I'm trying to understand why 15 of the last 22, particularly when there's overwhelming lack of participation in the reunification plan, serious substance abuse problem that has never been handled, all the things that we look at where we're saying, it's more likely than not that she's never going to get it together. But they're leaving her in the picture, and I don't understand why that's happened. For the reason that I state, that's what I was told. Because we have a parent who's going to have her legally, it's up to the parent to protect, the child, Why have that statute if we're not going to follow it?
I think there's a couple different answers. First off, I think a parent, I'm sorry, the repeat, gosh. There's a lot of it, so I'll try and do it. I think your first question was whether or not a parent can file a TPR against another parent. I think the answer is absolutely yes. And so then you were saying that you've been told no, that you can't, because that would leave essentially only one parent.
They were told that the state and or NFC will not be filing it, because that would only leave one.
So he says that in his case that the state or an FC is not going to be filing a TPR even though we may have 1522 or we may have cause. They're not going to because it will only leave one parent. I think that analysis is the best interest part of a TPR. You first have to prove up the statutory ground, and then the second element is you have to prove up best interest. It's in the child's best interest that the rights be terminated. For some analysis of that is that even if parent is completely unfit and should never have any contact with this child, they still have money, and they can still be paying child support, and there can still be inheritance rights, and they can still get shivved in jail and get a huge settlement, and that will come to the kid. So that's the analysis for the best interest element, but that, to me, that's a trial issue. And an attorney can definitely, county attorney or HHS or state or NFC, you know, whichever letters you want, can say, I have determined I do not think it's in the child's best interest, so therefore I'm not going to file. However, I think with the statute, if there's not an exception, then they are mandatory to just file, and then I think you can do a motion for contempt, because they're in essentially a show cause order that they are not following the statute. The statute says shall file. I think that's frankly one of the problems with the statute, because if the county attorney says, I know I'm supposed to file a TPR, I can't win a TPR, and I shouldn't be filing for those lawsuits, because, you know, for instance, for the best interest element, I don't think the statute gives them that out. There is no discretion within that statute.
Well, what you're saying.
I think Neely wanted, before you follow up with that question, you want to?
The only thing I was going to add is that what I heard you saying is that the reason that you were given for why they weren't moving forward with a TPR, even though you'd reached 15 out of 22, was because there was a biological parent who could safely assume custody of the child and would be able to provide for the protection of that child. And in the 15 out of 22 statute, one of the exceptions is that the case plan and court report of the department documents a compelling reason why moving forward with TPR wouldn't be in the juvenile's best interest. And I might not be stating that word for word. I don't have my statute book open, but it's relatively close to that. And so assuming that the exception hearing was actually held in your case, I would guess that that's what the court is basing its opinion on, is the exception to the county attorney being required to file the TPR, even though we've hit 15 out of 22, is this compelling reason that there is a bio parent who can assume custody. So I just wanted to say that I think there would be an argument for why that reasonably could fit within one of the exceptions. So,
Isn't one of the exceptions that they're placed with a family member?
Placed with a relative, yes.
Yeah. And it may be the 1522, that may not be out-of-home placement would be the other argument. If the child is placed with non-offending parent, is the child really out of home? Because you can have two homes. You don't have to be only the offending parent doesn't have to be the only home a child has. So I would argue if the child's placed with dad, child's still placed at home, it's just not the home in which the child is removed from.
I get the idea between it's mandatory that you shall file. But as a county attorney, I'm not going to file a case that I can't prove. So if someone did file a contempt order, that's fine. I'd address it. I'd file it. I'd dismiss it 2 hours later because I can't prove the case.
I agree. I'm not criticizing county attorneys who don't file TPRs so they can't win. I think the problem is in the statute, it gives no discretion. So if you are a parent's attorney or GAL, so if you're a parent's attorney and you think something should be filed, I think your remedy is to file an order to show cause, and the judge can say, I don't find that there's contempt, that the county attorney has good cause, and address that statute.
But the language is shall, though, right? It's not a may.
The language is shall, unless an exception applies.
And that may be the reason then to say there is a compelling reason and just kind of trigger all that we need to start documenting better so that it isn't just, well, you know what's going on, we're just not following the statute, so that there is actually documentation of there is a reason, and there's definitely cases where child's been out of home 1522 or there's something else, but there's a major flaw in the fact pattern that a county attorney doesn't want to file. I totally get that.
And I would also say, as guardian ad litem, I think looking at the best interest of the child, it is the best interest of the child to determine should we be moving forward with the TPR or should we not? So if you aren't seeing these exception hearings being held in your courts, I think that you could easily file a motion to request that an exception hearing be held, just so one way or another there's a determination made as to the county attorney or whoever has the burden to file a TPR based on the statute, or the court finds, and it's the court, it's not the county attorney or anybody else, there's supposed to be a hearing and the court finds that there's an exception to the requirement that a TPR be filed.
Any last words? Anyone?
I just, in the materials, my email address wasn't in there in case you have a complaint. It's lgendler@sarpy.com, so feel free to email me, but thank you for all you do.
Everyone else's contact information is in the back there too, right? I think I saw it. Yeah, so, and they all said they'd be open for questions and everything, so. Thank you again, everyone, and to our wonderful panelists, and happy St. Patrick's Day.